I'm Drew Stevenson, and this is a video for my professional responsibility class about ABA Model Rule 1.10. This is part 2. I have 2 videos about this. In the first video, which I hope you've already watched, I go through the provisions of the rules, sections A through D, and here I'm going to hit the highlights of the comments and also some tips that I think you'll find useful in practice. I'm going to focus on the comments here in this video that I think are most likely to show up as test questions. So as a quick reminder, 1.10 is about imputed conflicts of interest. So one lawyer in the firm has a conflict under Model Rule 1.7 or 1.9, and that will be imputed to all the lawyers in the firm unless the firm implements screening procedures. And you may remember from the prior video that I said that this particular rule is awfully worded. It's very long, awkward, confusing sentences. And so what I've tried to do is paraphrase the rule provisions to make them clear for my students, but at some point you should actually sit down with the text of the rule. I have the link in the description to these videos, and read through the text slowly so that you've read it at least once. But my goal here is to focus on comprehension, or making sure you understand what the rule means and what it implies and how it's going to show up in test questions. And as a reminder about 1.10b in particular, it operates to permit a law firm under certain circumstances to represent a person with interests directly adverse to those of a client represented by a lawyer who formerly was associated with the firm. So this is pretty important because sometimes lawyers leave firms and then the firm wants to represent a new client, and the client, that lawyer who left, took their clients, his or her clients, with them when they left. Also keep in mind that this rule applies regardless of when the formerly associated lawyer represented the client. Don't get tripped up and if you have an exam question that tries to throw you off by saying that the representation in question was only a few months ago. It doesn't really matter for purposes of this rule. On 1.10, if it's a former client, if the representation was 6 months ago or 5 years ago. Now remember that 1.10b also refers to 1.9 and confidential information. And 1.9 itself says that with the passage of time, information becomes less and less likely to be relevant and material for new legal disputes or matters that arise. And also it's more and more likely to become generally known by the passage of time. So if the representation was 20 or 30 years ago, the rule could still apply. We're not just going to say, well, that was a long time ago, but it becomes less likely that there will be confidential information that's material for a new matter. There's something else I want to tell my students about the phrasing of the rule that you should be aware of. Don't call screening under 1.10 a Chinese wall. In the past, the legal community referred to screening as a Chinese wall, alluding to this type of movable room partition that I have pictured here, which people can set up to kind of subdivide a room and create some privacy and things like that. Of course, you can overhear conversations on the other side of the partition, but you should be aware that if you read old cases about imputation and screening, that a lot of court cases and ethics opinions referred to screening as having a Chinese wall at the firm. And you also may hear lawyers wherever you work after graduation, if they graduated a long time ago, they probably went to law school when everybody was calling this a Chinese wall. You should not. There's no reason to make this an ethnic thing or to refer to another country. The ABA consistently refers to it as screening, and so should you. So the model rules say screening, ABA ethics opinions say screening, and the MPRE is going to call it screening. And that's what you should, if you're planning to graduate from law school soon, that's what you should be calling it as well. Now, comment 3 gives a few examples that are easy to turn into multiple choice exam questions. Here's one. A lawyer in a firm can't effectively represent a client because of strong political beliefs. You may remember my example under Model Rule 1.7 for material limitations, that sometimes a person is very passionately against abortion, opposed to abortion, or very, very passionate about defending abortion rights. And so that can affect whether they're really the ideal lawyer to represent a given client. But if that lawyer is not working on the case and their personal belief will not really materially limit the representation by others in the firm, the rest of the firm won't be disqualified. And so if you have one lawyer who's, I have a picture here of a QAnon protester who's actually believes in QAnon. That's pretty unlikely for a lawyer, or really, really gets upset about it and so forth. They might not be the best person to represent a client who's kind of an adherent of that type of political view or a political dissidence. But the rest of the firm could. There's going to be other lawyers who don't feel as strongly about the issue, who could set aside their feelings or views on it and represent a client even though they disagree with the client. And so the firm won't be disqualified, assuming that the lawyer who has the material limitation can't coerce or bully or influence the other lawyers in the firm. But on the other hand, if an opposing party in a case were owned by a lawyer in the law firm and others in the firm would be materially limited in pursuing the matter because of loyalty to that lawyer, the personal disqualification of the lawyer would be imputed to all others in the firm. And so, for example, I've given this example before in previous lectures. Let's say there's a partner at your firm that is really intimidating. Everybody's afraid of this person. He's kind of bullies people and is coercive and abusive and so forth. And you want to represent someone who's suing a company, and that partner owns $100,000 of stock in that company or $1 million of stock in that company, and is going to try to coerce you or pressure you to not try that hard in the case or to settle the case for a lower amount or something like that. Well, if there's someone at the firm who exerts that type of pressure and influence over others and they have a conflict of interest, then the whole firm should really be disqualified. So in some ways, it's the opposite of the scenario on my previous slide. Now, what about non-lawyers? So law firms have receptionists and paralegals and secretaries and so forth. So 1.10a does not prohibit representation by others in the law firm if the person with a conflict of interest is a non-lawyer, right? So we don't have as strong of a presumption of imputation for paralegals and legal secretaries. And the same is true if you have a lawyer whose conflict is because of work that they did when they were a law student before they became a lawyer. Now, keep in mind that such a person should be screened from any personal participation in the matter in order to avoid communication to others in the firm of confidential information that both the non-lawyers and the firm have a duty to protect. Now, why do we have sort of a relaxed standard about this? Well, because the secretary, let's say, or paralegal or law student is less likely to have provided full representation of the client and have been privy to all of the confidential information. So a lot of law students, when they have a summer internship, do a few research memos related to a client and so forth. But even so, I would advise law students, while you're in law school and you work for a firm during the summer or maybe part-time during the semester, to keep a little log of all of the clients whose matters you work on and what the matter was and so forth for your own records, because after graduation, when you start your career as a practitioner, if a case could come up where you kind of need to notify the firm that you worked on a matter for the other party that was related, or there's a risk of the firm being hit with a disqualification motion, and so they should probably screen you from the case right away because as a law student you did some work for the other side, just to keep that in mind. Now, comment 5 is a good reminder. Even with screening, a firm may not represent someone with interests adverse to those of a present client in the firm. So make sure you're crystal clear on this in your mind. we never ever have a situation where the same firm can represent the plaintiff and the defendant in the same litigation. And there's no amount of screening we can do in the firm, like to screen those lawyers from each other. So you can never use screening to try to solve the type of conflict of interest of current clients with directly adverse legal interests. And the same would be true with the buyer and seller in a business negotiation or something like that in a commercial sale. And keep in mind that screening an individual lawyer is ineffective under this rule of any other lawyers, and the firm have already learned confidential information that's material to the matter from which the lawyer is being screened. So this should seem obvious, but screening, it defeats the purpose of screening if before the conflict was identified or the other side filed a motion for disqualification, if you've already talked to other lawyers in the firm and disclosed a lot of confidential information that gives them an unfair advantage or could be used to the disadvantage of a former client, then what's the point? Imputation doesn't do any good, right? The cat's already out of the bag. So in that type of case, a court is likely to still disqualify the firm because the information has already been divulged or shared. And remember, if you from the previous video went under Rule 1.10, the lawyer has to be timely screened, and timely means before they share confidential information that would be disadvantageous or prejudicial to the other side. And then this is always a good reminder with a lot of the rules. Remember that even where screening mechanisms have been adopted, tribunals may consider additional factors in ruling on motions to disqualify a lawyer from pending litigation. So ultimately, a motion to disqualify is up to the discretion of the judge, and they're going to weigh a lot of factors. It's not an automatic save that your firm has some basic screening procedures in place. If there's other extenuating circumstances that the judge is considering, maybe this firm has a history of sort of not really following through on screening procedures, or it's a high stakes matter, and there's other reasons to be concerned, the judge could still decide to disqualify a firm even though they say that they've implemented screening procedures. So keep in mind, now probably if the firm is following the rule and they've in a timely manner have implemented screening procedures and provided notice to the other side, a lot of times the judge will say, okay, you're complying with the rule and we won't disqualify your firm. But it's always possible the judge could say, well, there's some special circumstances here and I'm still going to disqualify, impute the conflict of interest to the whole firm, and disqualify the firm from the representation. And now also keep in mind 1.8 we haven't really talked about, and a lawyer is prohibited from engaging in certain transactions under Rule 1.8. Remember that 1.8 had its own imputation rule under subsection K of that rule, and there's no screening mechanism for that except really the section of 1.8 about having a lawyer having sex with a client. And so normally if it's a conflict under 1.8, like business transactions with clients, that's going to be imputed to the firm, and we're not going to be able to probably apply screening except to the extent that paragraph K applies. But you may also remember the paragraph K says that a lawyer who is disqualified or has a conflict because of getting involved in a sexual relationship with a client, that is not imputed to the other lawyers in the firm. Another lawyer in the firm can take over the representation at that point. And because the type of conflict is so personal that we wouldn't assume that the other lawyers would be affected by it. And that concludes our videos about ABA Model Rule 1.10.